This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we have Mr. Hivner call the case, just to mention that if we don't anticipate any technology problems, but if we should have any, we'll just take a pause and resolve it and then proceed from that point on. Mr. Hivner, call the case, please.
In re Estate of Dorothy Jean McMillin.
We'll hear from the appellant.
Good afternoon, Your Honors. Bruce Hill with the Sevier and Knox County Bar. I represent the estate of Dorothy Jean McMillin. And as this court's aware, this is a case that was resolved on motions for summary judgment. This is a case that's a primer for what can go wrong with an irresponsible, or perhaps even worse, person who gets hold of somebody else's money. This court may be familiar with Paul McMillin. There's been prior litigation, and it's mentioned in the brief that prior to the death of his mother, the decedent in this case, Dorothy Jean McMillin, he removed somewhere in the neighborhood of $615,000. So he didn't remove it. He actually just became a co-owner of accounts totaling $615,000 plus some change with his mother prior to her death. And then the beneficiaries got wind of this, filed suit. There was a jury verdict in that case, and a jury verdict was rendered against.
Yeah, Counselor, answer me a question here, if you could. How come this case could not have been considered in the initial case? And why is at this point this is not collateral estoppel or res judicata?
Well, it is a different kind of case, and certainly that's at first glance you think, why couldn't you do that? Well, the money that was involved, the preceding case involved did not involve a personal representative who was essentially appointed as a fiduciary who had duties to preserve and protect a decedent's money. This was a case that prior to her death, he did have a power of attorney, but he didn't exercise that power of attorney. This was just simply essentially next to friends going against Paul McMillin for taking money before his mother even died. So it's a separate type of lawsuit. This is an estate. What we're here before is on an estate where a man has been appointed by the court to manage different money for the benefit of for beneficiaries. He was not appointed in any capacity other than the power of attorney prior to her death. So it's two separate cases. This is more of a breach of a fiduciary duty, where the prior case involved a different type of scenario, an undue influence, where Ms. McMillin was still actually alive, at least at the time the transactions occurred.
So the second case then, and it was after she had died, is that correct?
Yes, correct. We ended up trying the first case after she had died, but it involved, it had nothing to do with the administration of an estate or monies that Mr. Paul McMillin had gotten, became in charge of after marshaling the assets after death. That involved estate money. This just involved Ms. McMillin's money before she died, just as an undue influence where somebody swoops in and says, I'm going to be your caretaker, and gets hold of her money, and there it goes. And little did we know that once, and he ended up being removed by the trial court, and this court heard the appeal on that and sustained it. He was removed as personal representative, and here we discover a different kind of abuse, where he again took advantage, this time not of his mother, but of the beneficiaries of the estate.
Okay.
Okay. So just a quick, I know we don't, these go quickly. A primer, the court, when I filed this appeal trying to get a final order, I did ask the court to do an interlocutory appeal, because there is a provision in the will that does provide that the executor may make a claim for attorney fees in defense of any of his actions. And I had asked the court to just simply do an interlocutory appeal and reserve that issue. And the trial court, for whatever reason, didn't want to do it that way, but just said, look, it's a final judgment. anyway, and I reserved the right to look at the attorney fees. And the reason I did it that way was because it was discretionary. The court knew we were going to appeal it, and for judicial economy, it a whole lot of sense to have a hearing on trial court attorney fees, and then have an appeal, have a hearing on those fees, or whatever this court does might in fact obviate any award made in the prior case. And under Rule 54.02, I point out to the court, as long as one party has gotten all relief it's entitled to, it's a final judgment subject to appeal, and that is the case in this here. Mr. Olivier's client, he can seek attorney fees later, but the estate, all of its claims are resolved in full, and that's why we're here today. That's why it is proper for the court to go forward. The reason I brought up the prior jury verdict is because it's relevant in that the defense of how all this money was used was the same in the jury trial case as it was in this case. Under oath in the jury trial, Mr. Paul McMillin swore that all the money he got, and it turned out it was $615,000 plus some change, he spent it all on building this house. That was his testimony. Jury verdict of $284,800, which was roughly the difference between what he took and minus the appraised value of the house. That was roughly the jury verdict. That was appealed. Judge Frierson, on his appellate decision, affirmed that case and noted exactly that it was a reasonable jury verdict because it's more or less tracked the difference in the money he took and the value of the house, the appraised value. Well, once, and of course, that judgment against Paul McMillin, that became an asset of the estate of Dorothy Jean McMillin, didn't it? So when we filed a motion to have him removed when he would not pay it, we had a hearing on that, and the trial court removed him, noting, of course, that he had just a conflict of interest. As the administrator of the state, he's got the duty to marshal the assets. The judgment was one of them. He wasn't going to pay it to the estate against himself. So he was removed. And then a new administrator was put in, and after a little bit of discovery, found out there's another $177,000 from a Fidelity account that had been deposited. It's gone too. Long story short, took a deposition, and Mr. Paul McMillin said, yeah, I spent all of that on the house. Well, that's under oath. His jury trial testimony was under oath. So we've got him under oath saying, look, I spent $792,000 plus building this house. The trial court approved this thing, sat on the MLS for 2 or 3 years. It took a long time to sell it. It only sold for $275,000. And how do you spend $792,000 to build a $275,000 house? So that's the basis of this case, which is incredible waste if we assume that what he said is true. Now, it's possible he didn't spend that money on the house. He might have pocketed it like he did in the jury trial case, but assuming from summary judgment motions, that's how he used the money. He's bound by that testimony. He's bound by it, and that's what we have. That's why we filed motions for summary judgment. Under any view of the reasonably prudent investor standard, nobody would spend their own money, $792,000, to build a $275,000 house. Trial court overruled our summary judgment, and part of our appeal is that is incredibly deficient order. I mean, it just makes no findings, no conclusions, no analysis. It just says this fairly, I think, well-written and long and well-documented motion summary judgment overruled, period, end of it. Now, Mr. Lavier's filed a counter motion for summary judgment. There was some discussion about it, but at the end of the day, I won't go into too much more than we have to. Still, at the end of the day, what the trial court did not do, the trial court had to do, was make an analysis of the reasonable investor standard. When we had oral argument and I made the point to the court's got to apply reasonable, does a reasonable person spend money this way? And the court said, well, what am I supposed to do, Mr. Hill, drag in a bunch of reasonable people to hear this? Well, that's not the case. Of course, the trial judge is the jury. The trial judge just simply applies that. The trial court did not do that. The trial court's sole basis, as far as I can understand the word, it's very confusing, simply locks in on half of a sentence, which says my executor is given wide discretion. So that's what the trial court did, gave him wide and essentially unbridled discretion, made no analysis whatsoever as to whether this fiduciary's management of estate money met the reasonably prudent investor rule.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
May it please the court. I am Thomas Levier, and I am the attorney for Paul McMillin, who was the defendant in the trial court. This case is a perfect example of hindsight being 20/20. And I certainly understand why the plaintiff and counsel for the plaintiff are attempting to point to the prior case and the findings in the prior case and the fact that the prior case made it up to the Court of Appeals and was addressed in the Court of Appeals. That case did involve different factual circumstances from the case at hand. It involved different monies and it involved different claims. The claim in the prior case was a claim of undue influence. Mr. Paul McMillin represented himself as the defendant in that case pro se and went to trial pro se. And that resulted in a jury verdict against him in the amount of $284,000. The court has brought up the issue of whether res judicata or collateral estoppel should apply in this case. And I would point out that on the motion for summary judgment, the plaintiff had taken the position that res judicata and or collateral estoppel should apply in favor of the plaintiff to prevent the defendant from raising his defenses in this case. And at first blush, I certainly thought the same thing. Why could these claims not have been prosecuted together? And if they had been, or if they had not been prosecuted together, why was the claim of the plaintiff not barred by res judicata or collateral estoppel? And here's what I think is the difference and the reason why those judicial or collateral estoppel and res judicata don't apply in relation candidly to either side is because of the differing standards. The standard in relation to the prior case was whether undue influence was proven by a preponderance of the evidence. Here we have a very different situation. There's a will involved, and we have to look at the language of the will that sets forth the standards by which Paul McMillin, as the prior personal representative, was able to deal with this real property. And I'm going to certainly address the specific items in the will or the specific language in the will in the brief that was filed, but I do want to point out some of the very broad language that was used by the decedent when she drafted her will. She said in item 6 of the will, my personal representative shall have full authority and discretion to convey, improve, lease, encumber, or in any other manner deal with and administer any real property. It goes on to say in item 10, granting the personal representative continuing absolute discretionary power to deal with any property, real or personal. And then further in item 11 of the will, the fiduciary is granted indemnity. It says, unless a fiduciary acts capriciously and arbitrarily, my estate or a trust shall indemnify the fiduciary for all expenses, including attorney fees, which he or she incurs or expends or arises from the exercise of his or her discretion. And this is where the hindsight being 20/20 really comes into play. Because what the plaintiff is attempting to do here is go back and question the manner in which Mr. Paul McMillin dealt with this real estate, dealt with the funds in attempting to improve the real estate. Now the facts here.
Levier, I'm sorry to interrupt you, but is there any indication in the trial court's order that the trial court did any analysis about whether whether the actions of Mr. McMillin were arbitrary or capricious?
Well, and I will say I do not have the order in front of me, so I cannot refer to a specific language in the order itself where he addressed that. But he did address the standards under the will. He did it in the order that was drafted. The trial court did address the discretion and the absolute authority that was granted to Paul McMillin as the personal representative to deal with real estate, and that he was exercising, and this is, I think, what the order does say, that he was exercising good faith. So in other words, while the court may not have specifically addressed arbitrary and capricious, the court did find that under the undisputed facts that were in the record, that Mr. Paul McMillin at the time, and I think that's the important thing, at the time was acting in good faith. And so I think that's where that the trial court did properly address this and did properly deal with the standards under the will.
What were those undisputed facts?
Okay, and that's extremely important, obviously, on a motion for summary judgment. So I'm glad Your Honor asked that way. First off, Paul McMillin did come into contact with these funds. The amount of the funds actually was initially $477,000. He then distributed all of that to the beneficiaries under the will. There were four siblings, and those funds were distributed under the will, leaving $177,000 that the amount was left over. So what the testimony of and what is in the record as the undisputed facts is that Mr. Paul McMillin used that $177,000 solely in relation to this real estate. He didn't use it for any other purpose. He used that $177,000 solely in relation to this real estate and continuing to improve the real estate. Other undisputed fact that's important to note.
All right, no, wait, let me make sure. I haven't looked at this, so I apologize for that. But are you saying that that was a statement in your statement of undisputed material facts that he spent $177,897 on the improvement of this real estate, and they admitted that that was undisputed? The answer to the first part of the question, yes, we put that in the statement of undisputed facts that he used the $177,000 to improve the real estate. Was that disputed? Here is how I understand the plaintiff is disputing that. They are saying, well, yeah, you used the $177,000, but you also used the $615,000 that was involved in the other case. So the way that the plaintiff is making a dispute of fact in relation to that is by saying, oh, you used a whole lot more than $177,000. You really used over $700,000, and the house only sold for $280,000. But
did Mr. McMillin provide? I know apparently his testimony was he spent all that money on the house, but did he provide receipts or documentation for that, or was that part of the proof?
It was part of the proof, Your Honor, and that was originally put in the record in relation to the motion for summary judgment that was filed by the plaintiffs. What Mr. Paul McMillin did in responding to that motion is submitted a document, a summary type document, listing all of the expenses that were incurred and what they were incurred for, and included copies of checks and receipts and things of that nature. So yes, the answer is those are in the record. Now, what the plaintiff is doing is the plaintiff has gone back and looked at the trial testimony from the first trial, and there's a very general statement that was made by Paul McMillin in the first trial. Very general, taken out of context. He says, I used that money in relation to the house. Now that's not an exact quote, but something to that nature. I used that money in relation to the house. The plaintiff is now expanding that and saying that his testimony was that he used the entire $615,000 in relation to the house. Well, in responding to the motion for summary judgment, we pointed out, no, there was other testimony that was in the first trial, that some of the funds were used for other things, including there was a lot of excavation that had to be done on the real property. There was a second house that had to be maintained. There were ongoing expenses related to garbage collection, purchasing tools, all kinds of things of that nature. And all of that was put in the record in response to the motion for summary judgment that was filed by the plaintiff. So we have disputed the fact that they raised on their motion for summary judgment that the $615,000 was used in its entirety in relation to this same property. Because yes, at first glance, it would be somewhat concerning to anybody if somebody used $700,000 or $800,000 to build a house that ended up selling for $280,000. But that's not what the facts in the record show. That's not what the facts in the record show. The funds were used for other things.
Well,
Now,
what do the facts in the record show, undisputed, that he spent on the house?
Here's why I don't have a clear answer to that. The reason I don't have a clear answer is that there are some things that are vague as in relation to what was spent in relation to the house.
Well, if it's vague and unclear what he spent on the house, how can the trial court find there was no waste in spending the amount he did? I mean,
okay.
We don't know what that amount was.
But I don't think, I'll answer that in two ways. Number one, I don't think the issue before the trial court in this case was whether he spent the $615,000 on the house. We put in facts in the record that shows that he did not spend the entirety of $615,000 in relation to the house. The issue,
but we don't know, but there was nothing presented to the trial court showing here's how much Mr. McMillin says I spent on the house that sold for $275,000.
There is a summary. I don't have.
And my question is what is that amount that you say there's no dispute of that he spent on the house that then sold for this amount less?
Well, and here's why I'm equivocating and trying to answer Your Honor's question. Is there are certain things. For example, he purchased tools that were used in relation to building the house. Those tools were subsequently stolen and were lost to the estate. Now, that's not something that's being sued over, but it is part. So is that a number that should be included in relation to building the prior house? What about maintaining the yard? What about excavating? I will say this. While I don't have an exact number for the court, I would say that it does exceed $400,000 in relation to those funds that were applied to the house in relation to the first set of monies, the $615,000. I don't have an exact answer for Your Honor.
How can we rule on this case without a list of undisputed facts or without a finding of facts by the trial court? We can't just rule on what each one of you saying was so or not. We need something concrete that we can look at. Why did the trial court make this decision that it made?
And I agree with what Your Honor says, but the issue is relation to the $177,000. He clearly expended those funds on the house. That's what the court was ruling on, not the prior amounts of monies. That's not what the court is ruling on the motion for summary judgment. It's the $177,000. And Paul McMillin does not dispute that he spent the entirety of $177,000. What we're saying is under his discretionary authority that he was allowed to use under the will, that he had the authority to deal with the real property and to improve it as he saw fit. We're not saying it's totally unfettered discretion. We're not saying he could have sold the house to his wife for $10 or something of that nature, but we are saying that there is substantial authority to deal with the real property, and the language of the will is the hindsight that is being exhibited in relation to this particular case is exactly the language of the will that the will was trying to prevent by granting such authority to the personal representative to deal with real property and to make the decision to improve real property. I do want to point out one thing real quickly because my time is almost up. We put in the record some statements of value at the time when all of this was occurring. And we're not trying to establish the value of the house or that it sold for an improper amount. What we're attempting to do is show the information that was available to Paul McMillin when he was making this decision. At the time he was making this decision, he was receiving information from a realtor that the house was worth more than $500,000. He received an offer of $495,000. These are the type of things that go into his good faith decision making that happened at the time, not sitting back here years later and looking back in hindsight and in relation to another case. I hope I answered Your Honor's question. I'm not certified fully did, but I certainly attempted to, but I see my time is up.
Thank you. We're here from the appellant rebuttal. Counsel, you need to unmute.
Sorry. Judge McClarty made a point I wanted to make is, this was a difficult brief to write.
I'm sorry. Never mind. Go ahead. We've got the time right now. I'm sorry. Go ahead.
This was a difficult brief to write because the order was just so it's just so deficient. There was just no findings of fact, hardly any, just a few. Our statements of undisputed fact were longer than the brief, the order of the court. It was very difficult to understand what this court was finding. This argument about Paul McMillin acting in good faith, that's disputed. If the court looks at the record, the court will see our response to that allegation disputed. So you can't find summary judgment on him acting in good faith if it was disputed. And as far as like the receipts go, there's stacks of receipts in this in this case in the record. Of course, these were the same receipts that Mr. Paul McMillin showed up at the jury trial with. He never put them into evidence, but he had the same receipts then. They're no different. They're just the same.
Are there any specific receipts that detail the $177,000 that's relevant to this case? Or is it just a big stack that goes towards the whole house overall?
There are a big stack of receipts. A lot of it, as Mr. Levier said, are for tools and things that were purchased. Again, those should be estate assets. That clearly this man spent more than $177,000 building this house. No question about that. We do not dispute that. But this $177,000, he may be able to show that was in fact spent on this house. But the point we're trying to make is prior to that, all this money he got his hands on before he became the executor, he started building this house before this lady died. He said he spent all that money on the house too. So just even if he's able to show, I can show that I spent $177,000, this $177,000, I can show I spent it on this house. That's not the end of the inquiry. He probably can show he did that. But the problem is, how much has he already spent on it? At this point, he's dumped so much money into it. When he got hold of this 177, the last thing he should have done was pour it into this bottomless pit of a house that he's supposedly constructed for the benefit of the beneficiaries. Now, another point Mr. Levier made, we can see that he had wide discretion. This is a will with fairly standard type of language. And in fact, he probably had the discretion to invest the estate assets into building a house. He probably could have done that. But whatever it is, whether he put it in the stock market or he built a house, or he bought some other form of investment, he still had to exercise. He should have spent the money as the will it says, as I would have spent the money myself. That's in the will. That's the rest of that sentence about discretion, as I would have spent it myself. So the question would be, would Dorothy Jean McMillin take $792,000, essentially all of her cash from her life, and spend it on a house that sells for $275,000? If we could exhume her and bring her back to life, I suspect she would say, no, I would not have done that. And for the purposes of summary judgment, maybe it's making too fine of a point. We can, for the purposes of summary judgment, not dispute one fact and then dispute it for a summary judgment from the other side. For instance, for purposes of for my summary judgment, I understand that the response may be, these are undisputed facts, and I have to assume those are in fact true for my own summary judgment. But now when Paul McMillin files his summary judgment motion, I have the right to dispute those facts. And for purposes of summary judgment, we have disputed these things, that whether he acted in good faith, whether it was reasonable to spend $177,000 of estate funds on top of what he testified was $615,000 he already spent on. Again, whether he spent on it for materials, for tools, for excavating, for subcontractors, all of that goes into building a house.
Let me interrupt you before you run out of time. In the first lawsuit, assuming collateral estoppel applies, just make that assumption. Is it your position that the jury found that he spent approximately $330,000 on the house in that first lawsuit?
Well, I don't know if I can say that for the collateral estoppel order. The argument I raised was in the event Mr. McMillin took a different view and said, defendant said, no, I didn't spend it on the house.
I understand. I'm saying that if the first lawsuit collateral estoppel applies, because the jury awarded the estate of judgment against him of I think it was $284,000, correct?
Yes.
Which would leave roughly $330,000 of estate funds that the jury must have found he spent on the house.
No, I think what the jury did was the jury just simply gave him credit for the appraised value of the house, because we put an appraiser on at the jury trial, and the appraiser said, this is what the house would sell for today. Now it ended up selling for less. So I don't think you can say that he said he spent it on the house. We don't know if he did or not in the jury trial. He said he spent all of it plus another $300,000. But what the $320,000 that looks like the jury gave credit to Mr. Paul McMillin was, it looked to me like they simply took what he took and subtracted out the appraisal value, because we had an appraiser testify as to the value.
All right.
320.
All right. Thanks to counsel for both sides. We appreciate your arguments this afternoon.
Thank you.
Mr. Hibner, if you will adjourn court till our next regularly scheduled docket.
This honorable court is now adjourned.